Hello there. Welcome to LHAG's mini podcast where we bring you bite-sized information in 5 minutes. I'm Shauna M. Thomas, and today we're looking at medical legal disputes. The topic for today's episode is the recalcitrant patient, and I bet some of you might be wondering, what does that even mean? Well, an individual who is obstinately uncooperative is who we call recalcitrant, and it really is not uncommon for a patient on the road to recovery to do some act that causes harm to himself. Personally, I've heard medical practitioners say that the challenge of getting patients to follow even the simplest prescription or instruction has emerged as one of the most difficult issues that they face on the regular. For instance, where the patient ambulates way too quickly post-surgery against advice and injures himself. The struggle is actually reflected in a paper by David G. McCurdy published in the Canadian Journal of Public Health, where he expresses that such individuals present a multitude of problems which usually follow the same pattern. You see, the patient has little regard for regulation, and it's rarely possible to please or satisfy them. In time, they create a situation that cannot be resolved and either leave against advice or they have to be discharged against advice. Some of you listening to this podcast might think that this issue is a no-brainer, that such individuals surely can be prevented from bringing an action. Others may wonder whether the law explicitly prevents such lawsuits. The short answer here is no, there is nothing to prevent a disgruntled patient from actually filing a lawsuit. But, there is a but. Whether or not the claim will be successful is dependent on a myriad of issues ranging from disclosure of risk to the existence of negligence in the course of diagnosis and treatment. That said, even where a medical practitioner is found liable for negligence, the quantum of damages may be modified or adjusted where you are dealing with a recalcitrant patient. This is provided under Section 12, Subsection 1 of our Civil Law Act 1956, which states, where any person suffers damage as the result partly of his own fault and partly of the fault of another person, a claim shall not be defeated by reason of the fault of the person suffering damage, but the damages recoverable shall be reduced to such extent as the court thinks is just and equitable, having regard to the claimant's share in the responsibility for the damage. Now this, ladies and gentlemen, is what we call contributory negligence, and it is often raised as a defense in such cases. Well, how about the common law doctrine of voluntae non fit injuria? This is a Latin term which essentially just means voluntary assumption of risk by the patient. Does it prevent a claim? Again, it doesn't. The mere fact that the patient is aware of the risk or ought to have been aware of the risk associated with the procedure does not license the medical practitioner or institution to be negligent in their duties. After all, they do have an obligation to take all reasonable precautions to prevent harm from occurring. So ultimately, where a lawsuit is initiated by a recalcitrant patient and the defense raises contributory negligence, the court must determine whether the patient's intervening act would break the chain of causation and whether damages are recoverable in the present circumstances. To wrap this entire episode up, I'd just like to end with a quote from Lord Reed, which goes, "If the injured man acts unreasonably, he cannot hold the defendant liable for his injury caused by his own unreasonable conduct." Hope this has been insightful to you. With that, I'm Shauna M. Thomas. Hope you have a good week.